We all make promises, but in business, a promise is usually a contract. So what's a broken promise really worth? How do you actually put a price tag on that? Is it just about cleaning up the mess? Or is there a time for, actual punishment? To get to the bottom of this, we've got to jump back in time to a story about one broken part that, believe it or not, changed everything.
Okay, picture this. It's the 19th century in England. You run a flour mill. Your entire operation, your whole livelihood, hinges on one single piece of equipment. And then one day, crack. It breaks. Everything just stops. Now, this isn't some made-up story. This was the reality for a man named Mr. Hadley.
So here's how it all went down. It's really simple. Day 1. The mill's only crankshaft snaps. Total shutdown. The very next day, Hadley hires a guy, a carrier named Baxendale, to take this broken part to get a new one made. The delivery was promised for the next day, but that promise gets broken. Because of the carrier's neglect, the delivery is delayed by 5 extra days. And for every single one of those days, Hadley's mill is dead silent and he is losing an absolute mountain of money.
And this is where it gets really interesting. Hadley, of course, sues. But what is the carrier, Baxendale, actually on the hook for? Is it just the £2 delivery fee, or is it all those massive profits Hadley lost while his entire business was closed? This one simple question was about to change contract law forever.
The court had to find a fair, predictable way to sort this out. And what they came up with was, well, it was a pretty brilliant legal idea that we still use today, the foreseeability rule. And it all works with a simple 2-step test.
So the rule has these 2 parts. First, you look at natural damages. These are the losses that you'd normally expect to happen, the stuff that arises in the usual course of things. Think of it as the obvious direct result of the broken promise. Then you have step 2, which covers contemplated damages. These are losses from special circumstances. But, and this is the big catch, for the other guy to be liable for these, he had to know about those special circumstances when you both made the deal.
And you don't just have to take my word for it. Listen to what the judge, Baron Alderson, actually wrote. The magic words here are arising naturally, that's test 1, and in the contemplation of both parties, that's test 2. The whole thing boils down to one critical idea. What was reasonably foreseeable to both people when they shook hands on the deal?
So, how did it all turn out for poor Mr. Hadley? Well, he lost his claim for all those lost profits. And why? Because he never actually told the carrier, Baxendale, that his mill was completely shut down, or that this was the only crankshaft he had. As far as Baxendale knew, he was just delivering a broken part. He had no way of foreseeing that a few days' delay would cause such a catastrophic financial loss. Those special circumstances were never mentioned.
Okay, so foreseeability helps us figure out fair compensation for a normal screw-up. But that brings up a whole other question, right? What happens when breaking a promise isn't just a simple mistake? What if the other party's behavior is just truly awful? Should the law just try to make things right, or should it also try to punish them?
And this gets at 2 totally different philosophies. On one side, you have compensation. The whole point is just to fix the damage, to put the person back where they would have been if the promise hadn't been broken. It's about making them whole. But on the other side, you have punishment. And here, the goal isn't to fix the loss at all. It's to penalize the wrongdoer and send a powerful message to everyone else. Don't you dare do this again.
Now, this second type, the kind meant to punish, are called punitive damages, and this is absolutely crucial. You generally can't get them for a simple breach of contract. Contract law is about compensation. Punishment, well, that's usually saved for a different area of law called torts, which are basically civil wrongs, things like fraud or negligence that cause someone harm. But even when we're talking about torts, this idea of punishment is pretty controversial. And different countries have very different ideas about how far it should go. So let's look at a tale of 2 systems, the UK and the US.
In England, the courts are extremely hesitant to award punitive damages. A big case called Rooks v. Barnard basically said they're only allowed in 3 very specific situations. First, for oppressive acts by government officials. Second, if the defendant deliberately did something wrong to make a profit that they knew would be bigger than any compensation they'd have to pay out. And third, if a specific law says it's okay. And that's pretty much it. Punishment is a very, very rare exception.
But while the UK was drawing these really tight lines around punishment, over in the United States, a completely different story was taking shape. And this difference in philosophy led to one of the most famous and frankly most misunderstood lawsuits of our time.
Yup, we're talking about the hot coffee case. Now, what so many people miss is the jury's actual reason for their decision. They found out that McDonald's had received hundreds of complaints about severe burns from their coffee. They knew it was dangerous, and they consciously chose to do absolutely nothing about it. So for the jury, this wasn't about a simple accident. It was about punishing a company for its deliberate disregard for its customers' safety.
So the jury came back with an initial award of $2.7 million in punitive damages. Now that number sounds astronomical, right? But the jury had a clear logic. That number was equal to just 2 days of McDonald's coffee sales. The goal wasn't just to give money away. It was to get the company's attention and force them to change. A judge did reduce the amount later, but the message had been sent, loud and clear.
But this doesn't mean it's the Wild West in the U.S. either. The Supreme Court has stepped in and said there are constitutional limits. They've basically suggested that punitive awards should be in a single-digit ratio to the actual harm done. Anything that gets into, say, a 10-to-1 ratio of punishment to actual damages starts to look constitutionally suspect. So the punishment still has to fit the crime, so to speak.
So we've traveled from a little flour mill in 19th century England all the way to a fast food restaurant in 20th century America. Why does any of this actually matter to you today? Well, because the ideas from these cases still shape every single agreement you make.
Let's just put it all side by side. Compensatory damages from cases like Hadley versus Baxendale are all about making up for a foreseeable loss when a contract is broken. Punitive damages from cases like the McDonald's one are about punishing outrageous behavior, usually in tort law. They have different goals, different legal foundations, and totally different tests.
So, what should you take away from all this? 3 things. First, remember that contract law is about making things right, not about getting revenge. Second, foreseeability is everything. If you're facing a weird or special risk if the other person messes up, you have to tell them. Your silence could cost you. And that leads to the third and honestly the most important point. Clear communication, right from the start, is the best possible way to manage your risk.
And that really brings us to the final question. The real lesson from that broken crankshaft isn't just some dusty legal rule. It's a practical lesson in risk and communication. So the next time you sign a contract, or even just make a simple deal, ask yourself, have I made the special circumstances clear? Because understanding what's foreseeable could mean the difference between a small problem and a total disaster.